straightforward. It provides that the law governing the claim that is being assigned will determine its assignability, the relationship between the assignee and the debtor, the conditions under which the assignment can be invoked against the debtor, and finally the question of whether the debtor's obligations have been discharged. Again, this is fairly uncontroversial and essentially reflects the position under the Rome Convention. What is different from the Rome Convention is Article 14.3, which helpfully clarifies that Article 14 would cover outright transfers of claims, as well as transfers of security interests, pledges and charges. So far so good, and this is where it becomes a bit more difficult. There is a big question mark, however, over how you establish the governing law of certain other relationships that can arise on assignment. So, for example, what law governs the question of which party takes priority where you have two competing assignees, both of which say they are entitled to receive payment of the underlying debt. And this is very much a live issue at the moment, for reasons I will come on to look at in a minute. To understand precisely what those issues are, it's helpful to look back at what happened during the negotiations for Rome I, because it was at this stage that all of these questions were very much heavily debated. Now, we understand that during the negotiations, some states took the view that the question of priority between competing assignees is often simply a question of assignability. And as we have seen, Article 14.2 already provides that questions of assignability are governed by the law governing the underlying debt. However, other states took the view that these issues are actually proprietary issues rather than contractual ones, and so they simply don't fall within Article 14 at all as currently drafted. In other words, there was a lacuna in the regulation in relation to these matters. So this led to the proposal that, as we understand it, that a specific rule should be put in place to deal with these issues, and the suggestion put forward initially was that the law of the assignor's habitual residence should apply. Now, this was incredibly controversial and was one of the key reasons why the UK decided to opt out of Rome I in the early stages. The UK delegation and various financial market participants objected strongly to this proposed solution on the basis that it would be unworkable in the financial markets. So I've set out an example on the next slide, perhaps to help illustrate what everybody was getting worked up about. Now, it's a very simple example. It may not be representative of real life, but anyway, in this diagram you have X as an account holder on the left-hand side. Now, he deposits funds in a bank at a time when he's habitually resident in the UK. X then moves to France and he assigns the account to A1. He then moves again, this time to Russia, and when he's in Russia, he purports to assign the account again to another party, A2. Imagine then that the assignee 1 and 2 send conflicting payment instructions to the bank. What does the bank do? Well, it's critically important in these circumstances that the bank can establish whether A1 or indeed A2 has priority, so they can work out who to pay. If the law of X's habitual residence determined this question, the answer to this question, you can see why this could cause all sorts of difficulties. For a start, it would be very costly for the bank to investigate the law of assignment in both France and Russia. And also, even if it did so, French and Russian law could say different things about the question of priority, so the bank may still not have an answer. In the securitisation context, applying the law of the assignor's habitual residence would also mean, it is thought, much more due diligence would be needed on the underlying debts being assigned and on the question of whether the assignment to an SPV would give good title against competing assignees. So all very complicated, and as far as we're aware, still a live issue. The UK government did run a consultation on this particular provision a little while ago, and we are now waiting with interest to see how the Commission progresses with this issue. I think the likelihood is that the Commission will propose dealing expressly with this scenario in Rome 1, but it's a question of watching this space. So that's all on the specialist provisions. I'm now going to have a look at certain displacement rules, starting with the rules in Article 3 itself. So just to recap, we've seen that Rome 1 provides that parties can agree that they can choose the law to govern their contract. So what are the rules that might interfere with that choice, might displace that choice, or might trump that choice? So let's look first at Article 3.3. That provides that where all other elements relevant to the situation at the time of the choice are located in a country other than the country whose law has been chosen, the choice of the parties shall not prejudice the application of the provisions of the law of that other country which cannot be derogated from by agreement. So, in many international transactions, you're not going to have all elements located in one particular country. But let's say you're in a purely domestic situation, the parties are located in one country. The transaction is purely a domestic one, but some other law is chosen. Article 3.3 provides that if some other law is chosen, what the parties can't escape by doing so are those the laws of that the laws of that jurisdiction that can't be derogated from being applicable. So in the English situation, if there were English parties, it was a purely domestic transaction, but the parties for some reason chose the law of New York. If a member state was looking to determine that dispute, Article 3.3 may come into play if the parties were seeking to escape from certain mandatory provisions of English law. Let's say UCTA, the Unfair Contract Terms Act, might fall into that category because they're provisions of the UK which can't be derogated from by agreement. So that's how Article 3.3 may come into play. Another displacement rule that may be relevant is Article 3.4, and that provides that where all other elements relevant to the situation at the time of the choice are located in one or more member state, the party's choice of law other than that of a member state shall not prejudice the application of provisions of community law where appropriate, as implemented in the member state of the forum, which cannot be derogated from by agreement. So Article 3.4 is in similar terms to Article 3.3, but deals with provisions of community law. So that could lead to the mandatory provisions of community law applying if all the relevant elements are located in, let's say, Germany and Spain, or Spain, but the parties have chosen New York law. This particular provision is in red because it's new and there's no equivalent rule under the Rome Convention. The one thing I'd highlight in relation to both of these rules is the word all. In both cases, all relevant factors must be located in the relevant country or in member states. And so it is thought that in most international transactions, they will probably be applicable fairly rarely. So turning now to Article 9. This deals with what are termed overriding mandatory provisions, OMPs. Now, what do OMPs, what does that term mean? Article 9.1 describes them as, and I'm going to quote from this because this is a new provision, OMPs are provisions the respect for which is regarded as crucial by a country for safeguarding its public interests, such as its political, social or economic organisation, to such an extent that they are applicable in any situation falling within their scope, irrespective of the law otherwise applicable under Rome I. Now, Recital 37 provides some help as to the extent to which these OMPs might be applicable and gives some guidance as to their applicability, because Recital 37 states that OMPs should be distinguished from rules that can't be derogated from by agreement, and that was the term used, you'll recall, under Article 3.3. on the basis that OMPs, they say, should be construed much more restrictively. So this definition is new, again, which is why it's highlighted in red. But I actually think it's going to be quite difficult to work out in practice which rules might fall within this provision, because it's not as simple as saying, well, they're rules that can't be derogated from. One needs to look at 9.1 and to look at the guidance in Recital 37. There is no case law that I'm aware of as yet on OMPs. So whilst there is some academic commentary as to what these provisions might cover, there's no case law on this particular point. So when might OMPs apply? Well, Article 9.2 says overriding mandatory provisions of the law of the forum, that's the law of the courts determining the dispute, can be applied even if the law that would otherwise govern the agreement, for example the chosen law, is different. Now that's relatively uncontroversial and essentially reflects the Rome Convention. But what is new and more controversial in my view is Article 9.3. Now Article 9.3 says that OMPs of the place of performance may also be applied if the rules render the performance of the contract unlawful. Now just picking up on some of the terms in that provision, because I think it's important. Article 9.3 is new in the UK because the UK never implemented the precursor in Article 7.1 of the Rome Convention. And as originally drafted, it's interesting to note that Article 9.3 was much wider in scope, allowing the application of mandatory laws of a country with a close connection with the contract. And that was another reason that the UK decided to opt out, because of the fears that such a provision might create huge uncertainty. So on the plus side, Article 9.3 clarifies some ambiguities in English law about the extent to which illegality in the place of performance would be taken into account by an English court. And it is clear that the rule will apply no matter what the governing law of the contract is. But there are some downsides. For example, the use of the word may. The application of the rule is therefore discretionary, so it's unclear when a court will apply it and when it won't. And will courts adopt the same sort of test in its application? This adds uncertainty. What it means is that if you litigate a contract in England or other member state, which is governed by New York law, even if New York law regards a particular activity, regards a contract as enforceable, and even if English law or the law of the member state determining the dispute regards it as enforceable, the English court or other member state court may nevertheless have a discretion to apply the mandatory rules of a third state, i.e. the place of performance, if those rules would render performance illegal there. So this is an area of some uncertainty, and it has been an area of concern for commercial parties. It may lead parties to specify where the place of performance is and align it with other provisions in the contract. So the place of performance there's no risk of some third state laws being brought into play. Turning to certain further displacement rules, Article 12.2 and Article 21. Two final points. Firstly, Article 12.2 provides that in relation to the manner of performance and steps to be taken in the event of defective performance, the courts will have regard to the law of the country in which performance takes place. So arguably it's not a displacement rule as such, but certainly the have regard to suggests that courts might apply a different law. And it's certainly worth bearing in mind in any analysis. There is an equivalent provision in the Rome Convention, so the rule isn't new, but it is, however, unclear quite how far, if at all, member state courts will apply this rule in practice. Secondly, and more importantly, Article 21. Article 21 allows the courts hearing the dispute to refuse to apply the rules of law that would otherwise have been applicable if it would be manifestly incompatible with the public policy of the forum, that's the courts, the place where the courts are determining the dispute, to apply those rules. So that means if the contract is governed, let's say, by Indian law, but the dispute was being resolved before the English courts, if there was the application of Indian law would be manifestly incompatible with the public policy of English public policy, then the courts may refuse to apply that provision. Now there's little English case law actually on this in this area, but older cases suggest that contracts in restraint of trade or for bribery or concerning bribery could fall within this category. And so that's the final displacement rules I was going to consider. A few final points. Governing law and arbitration clauses. I've talked generally about the approach of member state courts to the application of the rules set out in Rome I. I think it's just in the commercial disputes context worth bearing in mind that an English-seated arbitration tribunal may not be bound to apply the rules in Rome I. The tribunal will look at, for example, section 46 of the English Arbitration Act, which provides that the arbitral tribunal shall decide the dispute in accordance with the law chosen by the parties as applicable to the substance of the dispute, or, if the parties so agree, in accordance with such other considerations as are agreed by them or determined by the tribunal. And 46.2 provides that for this purpose, the choice of laws of a country shall be understood to refer to the substantive laws of that country and not its conflicts of law rules. The second point to bear in mind is that relevant institutional rules also may have provisions relating to the applicable law to determine the dispute, and those should be consulted. Parties should still choose a governing law even where an arbitration clause is included, but it is important to consult as necessary institutional rules and the relevant arbitration legislation. So how should I provide for governing law in my contract? Well, the standard wording is that this agreement shall be governed by and construed in accordance with, and then you provide for the chosen law. Parties should also provide for a court, or if you're choosing arbitration, set out an arbitration clause. And generally we recommend that these clauses are dealt with separately, but do include them. Finally, I've set out in this slide some references and source materials, which, if you're looking at this area, you may wish to consult. I would flag up that any older texts that are based principally on the Rome Convention should be read with caution. I hope you found this interesting and helpful. Thank you very much.